Welcome to this special installment of Legal USA dedicated to H-1B working visa category. We would like to stress that the information provided here is not intended to be legal advice. Viewers should contact a qualified immigration attorney to obtain legal advice on their issue or problem. And now, I would like to welcome Ryan Sevchik, an immigration lawyer with Coley & Jessen Law Firm in Omaha, Nebraska. Thank you, Ryan, for being on the program.
Absolutely. Thank you for having me.
The Department of Homeland Security and Department of Labor passed two interim final rules that introduced changes to H-1B, H-1B1, and E-3 visa categories, working visa categories. What are the main changes and when do they go into effect?
Yeah, absolutely. So these rules, if they remain effective, which we can get to in a little bit more here as well, have to look at them in two different pieces. First, you have the regulations that are from the Department of Labor. And what those regulations do is they're effective immediately as the date of publication, and they significantly alter the manner in which the minimum wage or prevailing wage calculations are determined for purposes of sponsoring workers in H-1B status. With respect to the regulations from the Department of Homeland Security, they primarily affect the adjudication and how the United States Citizenship and Immigration Services will review and adjudicate H-1B petitions that are submitted. Those particular regulations are effective 60 days after publication. So basically it's a truncated comment period, but they are effective 60 days after publication. So when they were publicized on October 8th. So 60 days from that date would be the effective date of those. If these two rules remain effective, it will make it, number one, more challenging for individuals to qualify for H-1B status, and number two, more expensive basically for companies and employers to sponsor workers in these various non-immigrant visa categories.
Why will it be more difficult?
With respect to the USCIS regulations, is basically to narrow the manner in which individuals can qualify for H-1B status. So whenever we're prepping and preparing and working on an H-1B petition, two general pieces have to be the case. Number one, the position for which the company is sponsoring the worker has to be what we refer to as H-1B caliber. And then number two, the individual, the foreign national who's petitioning for that visa has to be qualified for that category. So what these new regulations do is they basically say that in order to hit that first criteria, that the position has to be, quote, H-1B caliber. In order for that to be the case, the position itself has to require a bachelor's degree in a very specific specialty related to that field in order to qualify.
So let's say I am a journalist and I would like to come over to the United States. And I'm competing for a position that is in PR, but my degree is in journalism. Will I be qualified or able to compete for that position?
Sure, very good question. And so that's a great example to use. So that's a profession where, as a general matter, I think most people would consider that a, quote, professional position, where it requires a bachelor's degree in one or more related fields in order to enter into that position. And that's been the general standard. And so, for instance, if your company were petitioning you for an H-1B visa, they might say, we will accept an individual with a bachelor's degree in journalism, communications, PR, and something else. Somebody has a professional degree, a bachelor's degree in those fields, they're going to be qualified for the position. What these new regulations would say is that might not now be an H-1B caliber position because it's too broad. The company is willing to accept a bachelor's degree in a variety of fields as opposed to this position will require a bachelor's degree in journalism. The easiest example of a position that is right now currently always considered H-1B caliber, or basically routinely considered H-1B caliber, you have a software engineer position. So generally speaking, a software engineer requires a bachelor's degree in computer science or a closely related field. I would anticipate that even with these change regulations, that would still be the case. With companies that require a bachelor's degree in a very specific fields. So where these new regulations narrow the field is where we're talking about those occupations that have traditionally been a little bit broader in terms of what companies will accept to qualify someone into that occupation.
You said that it will be even more expensive. What amount are we talking about here? And what has changed?
Yep, very good question there as well. So the Department of Labor, as part of the H-1B process, as part of any real employment-based immigration process, there are typically a couple steps. First, there's a filing with the Department of Labor on some level, and then there's a filing with the Immigration Services. So what we just talked about is the second piece of that equation with the filing with Immigration Services. The
Okay.
first part of that equation is with the filing with the Department of Labor. And for H-1B purposes, what we have to do is have what's called a labor condition application certified by the Department of Labor before we can move forward with that H-1B petition. And so in this situation, what that labor condition application does, what we have to do before we can file that, is basically come up with what's known as a prevailing wage, the minimum wage that has to be paid the H-1B worker in order to sponsor that individual on a visa. So right now for H-1B petitions, practitioners can run that calculation themselves. There's basically a formula that the Department of Labor uses. There are publicly available wage scales that grade each position in locations of the country on a 1, 2, 3, and 4 scale, 4 being the highest, 1 being the lowest. And so basically, depending on what the criteria are for the position, a bachelor's degree plus X years of experience, a master's degree, et cetera, that dictates where you land on that level 1, level 2, level 3, level 4 scale. So that scale is staying the same, but what's changing is the amounts that are attached to each level. So basically what the new regulations and the methodology from the Department of Labor will provide, I guess the result of what they provide is that the amount of wages will increase by 43% on the low end to 71% on the high end.
Okay.
And I can actually give you a real concrete example here.
Please.
So this is just this is a very common H-1B position for companies that sponsor individuals on an H-1B. So you're software engineer. Prior to these new regulations being effective, the level 1 wage, so the lowest wage an employer could pay an individual and sponsor them in the H-1B category for a software engineer position in the Omaha, Nebraska metropolitan statistical area. The prior level 1 wage was $61,027 per year. Under the new regulation, that level 1 wage increases to $93,101 per year. This is a level 1. This is entry level, so a material swing.
How about the fees? Have the fees changed here, Ryan, or is just the salary the main change in the regulation?
Yes, with respect to these regulations, the salary is the main change.
Okay.
Now, USCIS did actually publish some increases to their fee structure a couple months back. Those fee increases were scheduled to take effect on October 2nd, but they got enjoined by a federal district court in California. So those new fee increases are currently under judicial review.
Has the validity of visa changed? The length of H-1B visa changed?
It hasn't for your general situations where companies that are sponsoring individuals directly on an H-1B visa. So if you have a company that's sponsoring a worker for direct employment, basically employment with that company, and not placed at a different site or different third-party location, that's still a 3-year initial term plus a 3-year renewal. So what makes the H-1B category very attractive, especially for individuals from countries with immigrant visa backlogs, what makes it really attractive is that the company can continue to extend that H-1B indefinitely if that company and the worker are moving towards the employment-based lawful permanent residency or green card process. So you have that 6-year max, but there's the ability to extend it further. Now, where the regulations would change that is in third-party placement situations, where you have a situation where a company is sponsoring an H-1B worker and then they're placing them at a client site. In those situations now, the validity period would be limited to 1 year.
Can you please simplify the third-party location for us?
Right, and so this is very common in the IT industry, where you have companies that basically provide IT consulting services. And so what they'll do is they'll hire a lot of IT professionals that will be their W-2 employees, if you will. But then that company will enter into business-to-business relationships with other companies. Name your Fortune 500 company, and they'll effectively place one of their employees at that client's site. And so that's the third-party placement type situation.
Okay. Well, it looks to me, Ryan, that for new applicants starting on from December 7th or October 8th, things are kind of clear. But more than 500,000 non-immigrant workers are currently in the United States, and 2/3 of yearly H-1B visas are renewal cases. How much will this change the dynamics of this visa for those cases that will be renewed?
Absolutely. And so if these regulations remain effective, that will absolutely change that dynamic in a material way. The regulations as currently drafted will impact equally employers who are looking to sponsor brand new H-1B applications, or those employers that are looking to renew individuals who are already here in H-1B status.
Let's say I am at the end of my 3 years staying here in the United States, H-1B. I would like to extend. With the new rule, does the employer have to offer me a different salary? Do I need to negotiate a new contract?
So, very good question. With the new rule, again, depending on what the requirements are for the position that the company is offering, it may very well dictate or require a new salary based on the new wage levels. If you have a situation where a company is right now sponsoring a worker and just say a software engineer at a level 2 position, if you will, and the requirements of that position aren't changing, and now we go to do a renewal application, so it's still level 2, you absolutely will have a very material increase in that salary from what is currently there to what would then be the minimum amount required for the renewal. Now, there are situations where companies will pay above market. So, for instance, you go through this process and you find out that the Department of Labor requires at a minimum that the company pay this employee in this occupational category 60 grand. And maybe that company actually pays them 80 because that's what they pay similarly situated U.S. workers, which is the other part of the wage equation. And so now under these new rules, maybe now the new rules bring it right up to that. So it's still a level 2, it's still, you're still paying the individual worker the same amount. And so maybe there's no effect, but I think that'll be the exception rather than the rule.
What if I have a labor certificate already approved, but I have submitted my application with USCIS, however, USCIS is still reviewing my case. Will the new rules apply to my application?
So I think in that situation, number one, if your labor condition application was already approved prior to the effective date of the DOL's interim final regulations, then that wage rate that was reflected on that labor condition application will be set. And so the DOL portion of these new rules and regulations won't impact that petition. Now, the question would then become, if USCIS hasn't ruled on it yet and adjudicated it yet, whether those degree requirements that we talked about, if that structure is going to apply to it. And so 2 things there. Number one, we have to get beyond that 60-day effective point when these regulations become effective from USCIS without legal challenge, et cetera. And then number 2, determine how and USCIS is going to implement those. So typically speaking, when agencies implement regulations like this, they'll issue some sort of frequently asked questions or some sort of policy guidance that says what they draw the line in the sand of when they're going to start adjudicating petitions for the new regulations. And so you have to have that official confirmation from USCIS as to how they would adjudicate petitions that are kind of in the hopper, if you will.
Okay. So right now we don't really have that. Now, one more case. If I am abroad and I am in the same exact position, I have the labor certificate earned and I have submitted the application. Does the same scenario, we're talking about the same case scenario here, the USCIS, it depends on the rules that are in effect when USCIS will review the application?
That's correct. Yep, it'd be the same situation if the individual is abroad, and the timing would roughly be the same as well from the regulatory perspective.
Okay. Well, now, Ryan, something that goes beyond the H-1B, but I am a non-immigrant worker here in the United States, and I lose my job because of COVID. Can I legally stay in the United States? Or let me reframe my question. How long can I stay in the United States without a legal status? Or can I stay in the United States at all without a legal status?
Very good question. And so this primarily goes to which category that individual, what type of non-immigrant visa that individual held. So with respect to H-1Bs, just as an example, that the current regulations provide a 60-day grace period or up to a 60-day grace period following termination of employment in which an individual could lawfully remain within the United States. Now that's up to 60 days because number one, it's a discretionary period. And number 2, you have to have at least that amount of time left on your current H-1B approval. And so different categories have different structures similar to that of how long that grace period is. And what that effectively allows for is a period of time in which to either find new employment, so find another company that's willing to sponsor that worker in some non-immigrant visa status, H-1B, TN, E, O, et cetera. There's several options there. Or have that individual file for a change of status. So maybe that individual, they're here in H-1B status, they get terminated because of the COVID-19 situation. They may be changed to a B status for a visitor status to buy some time, basically, to again try to find an employer that's willing to sponsor them. So,
Okay.
and then at some point, there very well may come a time where that individual might unfortunately be out of options in terms of other sponsorship or other visa categories in which he or she could transition into.
And you said that you can transfer the H-1B from one company to another?
Correct. Yep.
How does that work? Can you give us an example?
Yes, absolutely. So the second company, so the company that's receiving or that's wanting to transfer the worker over to their employee, basically that company walks through the exact same process that an initial company would in terms of sponsoring that individual on an H-1B visa, but for the fact that you don't have to go through the lottery process.
Okay.
So you still have to do the Department of Labor filing, you still have to do the USCIS filing, you have to run through all the hoops. There's just not a requirement that that individual be subject to the lottery.
What is the processing time, an average processing time for H-1B visa? And will those regulations change the time frame, the processing time?
Yeah,
if they go into effect?
Yeah, absolutely. So very good question. So, with respect to the H-1B, if it's a a privately held company that's sponsoring the H-1B and going through that process, it is a capped program, meaning that there are 65,000 H-1B visas that are available every year, plus an additional 20,000 visas that are available for individuals who have graduated from a U.S. institution with a master's degree or higher. So a total basically of 85,000 visas per year. Typically, at least for the past several years, the demand for those visas has far exceeded that supply. And so when that happens, a lottery process is conducted. And so basically you have, roughly depending on the type of year and the type of petition, somewhere between 30 to 40% chance of getting selected in that lottery process. Once an individual has that H-1B, then as long as either that current employer or subsequent employer, as long as at some point in the line, within the regulatory timeframes, that individual gets sponsored on a permanent basis, or people move further enough along in that permanent basis sponsorship, there's regulatory allowances that then allow that individual to extend that H-1B indefinitely. Then the processing time of that is just based on the then current USCIS structure and how long they process them. Frankly, right now, that's actually been fairly quick on renewals. 2 to 4 months are the average processing times right now at both of the main service centers. So that's been a very welcome change. And those petitions are also, you can pay for an extra fee called premium processing in order to get them adjudicated quicker. So basically, if you don't win the lottery, then your options are to effectively try again the next year. So even it's not like the immigrant visa process or the green card process where your place in line is reserved, so to speak. Rather, with the H-1B, it's an annual item. And so if the lottery is not hit one year, then you basically have to figure out if there's other status and or work authorization that the individual can remain in here in the United States until that next point in time where the lottery window opens up for the H-1B visas.
This working visa category has afforded the applicant a path to permanent residency. Mm-hmm. Has that changed with the new rule?
That has not changed with the new rules. So with the H-1B category, and what makes it special, if you will, is that normally speaking, as you mentioned, individuals have 2 3-year stints in H-1B status, so for a total of 6 years. And at the end of that 6 years, typically speaking, they have to depart the United States and be physically outside the United States for at least a year before being then eligible for the lottery process to start it all over again. If an individual holds that non-immigrant H-1B status, and then you have an employer who sponsors that individual for an employment-based green card, as long as the employer takes steps in the process in a timely fashion, that employer can continue to sponsor that individual in an H-1B status indefinitely, beyond the otherwise applicable 6-year limit, until there's a visa number, an immigrant visa number available for that individual. And so effectively, as long as the employer either files the labor certification application or the PERM, which is the first step of the employment-based green card process, as long as that application is filed before the start of the individual's 6-year H-1B status, or the company has an approved I-140, which is the second step in that permanent visa process. If either one of those 2 items happen, then again, that company can continue to extend that individual's H-1B status until there's a visa number available for that individual based on the per country, per year limits.
What percentage of your clientele, for example, will be impacted by this new rule?
I think if these rules stay in effect, every single client that we work with that sponsors workers in these categories will be affected. And these are absolutely material swings in the wage rate. I understand the purpose of, obviously, the idea behind these regulations is protecting jobs for American workers. And so I think that's a valiant purpose. But at the same time, it's effectively going to price a lot of companies out of being able to sponsor for national workers. Even the largest companies are going to struggle with these salary levels, and for sure, your smaller to mid-sized companies will.
And this is a very recent rule, but have you had any feedback from employers that you work with on their reaction to this rule?
Right, and absolutely. And I think many are concerned, and rightly so. However, with these regulations, this goes back to one of my opening comments. I think right now we're taking everything that comes out like this with a little bit of grain of salt.
Okay.
So, obviously the Department of Labor regulations, as I mentioned, are effective immediately, or they were effective upon publication. The USCIS regulations were effective 90 or 60 days after publication. It's widely anticipated that, number one, there's going to be some level of legal challenge with respect to both sets of regulations. And then two, in that with respect to the DHS rules or the USCIS regulations, within the next 60 days, something is going to happen. A national election is going to take place. And so it's yet to be seen if there is a change in administration, if the new administration will abandon these proposed rules, their final rules, or continue their promulgation. So there's a lot of things that are up in the air on this. And so with many immigration changes that come out, especially in the regulatory sphere, oftentimes we take a wait and see approach. We obviously provide the information on what the regulations provide, but we don't get overly concerned about it until they finally and definitively become effective. And we know that there's not going to be a legal challenge that's going to overturn anything.
All right. Well, I have two last questions that are not exactly related to H-1B, but to the working visa category in general. We had a presidential proclamation in June, and now we have two interim final rules. How did these two things differ?
Very different structures there. So for most individuals, for most foreign nationals, talking about the H-1B category and most non-immigrant visa categories, you have to get approval from USCIS before and that governmental body has to approve that individual for that category. And once that you have that approval in hand, that individual can then go to the consulate abroad and apply for the actual visa that goes in their passport and then enter the United States in that category. There are definite exceptions to that process, but as a general matter, that's how the non-immigrant visa process works. These new regulations are directed at the USCIS adjudication of that equation. So the USCIS adjudication of those petitions to see if the individual qualifies for whatever visa category they're asking for. What the proclamation did is it basically stopped the consulates from issuing visas in those categories and thereby suspended effectively entry for individuals coming into the United States in those categories. A company could sponsor somebody on an H-1B visa, have everything done with USCIS, have the approval in hand, but that individual can't physically go to the consulate to get the visa and therefore can't physically enter the United States.
Okay, and the proclamation I read now that was challenged and the federal court stopped the ban. Am I correct in that information?
So on the visa suspension that came out in the end of June, a portion of that has been stopped, but it's just as to the named plaintiffs in that lawsuit. So there are several large companies that signed on to that judicial action that basically stopped the implementation of that ban. But it's not a nationwide stop. It's just as to the companies that actually were part of that litigation.
Okay.
There's been other challenges that are nationwide and broader, but unfortunately, this particular challenge is just related to those named plaintiffs at this time.
Okay, so in other words, the proclamation is still in effect?
Correct. Yep.
Oh, okay.
Right now until the end of the year. So.
Okay. Now, the last question that I have, and I'll let you go, Ryan. We hear a lot about abuse of this visa category, and it was one of the main reasons why we see all these changes. Do we have facts for that? Is there really abuse of the category?
Yeah, so that's one of those things where, I'm not naive enough, and I don't think immigration practitioners in general are naive enough to think that every company that ever sponsors somebody is squeaky clean. Now, as far as full-scale abuse, I don't see it. I certainly don't see it in my practice. The companies that we work with are absolutely in desperate need of these workers, and that's why they pursue these processes. I mean, if you think about it practically from just a pure capitalist business perspective, it is not inexpensive for companies to sponsor workers through these visa programs. Yes, there are probably some level of abuse, and you probably have some bad actors, but I think trying to address that problem and those small number of bad actors with regulations such as this that cast a very wide net is kind of the equivalent of the adage of trying to kill a fly with a sledgehammer, because I think that the problem is so minuscule in comparison to what these regulations are doing and the number of companies that these regulations are affecting.
Thank you, Ryan. I really thank you that you found time to answer our questions. I assume that you are very busy nowadays.
Absolutely. No, I appreciate the opportunity, and I'm glad to be here.
This was Legal USA. If you find this information useful, please subscribe to our channel. Thank you for watching. I am Enkela Vedio.